Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions in this series, and today our topic is using property. One of the most basic sticks in the Blackstonian bundle of sticks is the ability to use property. But as other videos in this series have shown, there is a significant constraint on the use of property through zoning laws. Zoning codes, however, do not constrain what we call nonconformities, nonconforming uses, structures, or lots, which were once legal, but now are not. You only know what a nonconformity is after a zoning code changes and renders some activities or structures or lots non-compliant. I'll give you perhaps the most common example of nonconformities. Nationally, we see nonconforming housing uses in older cities, which previously allowed duplexes or accessory dwellings or housing above shops. Many zoning codes changed to prohibit those kinds of uses and restrict housing to single family or ban housing from our main streets, even though it has been there historically. What continues to exist, however, is protected as a non-conforming use, even if it's illegal under modern codes. A nonconformity is a thing that cannot be seen on a zoning map. It's typically declared by staff after staff does research onto the history of a property. In finding a nonconformity, there is no rezoning. There is no showing of hardship through the variance process. There is no review for a special exception or conditional use. The nonconformity, once found on the facts, is generally allowed to continue without triggering any of the flexibility devices we discussed in another video. Depending on state law, this nonconformity may be phased out or may be phased out only if it's a nuisance or if it has been shown to be abandoned. So let's talk a little bit about abandonment. In most states, abandonment requires a showing of intent. So how do you find that a property owner intends to abandon? It could be voluntary demolition. It could be through failure to apply for licenses or permits to continue a non-conforming use. If a structure is totally or partially destroyed, some jurisdictions allow the structure to be reestablished, even if it was non-conforming, while others do not. So you'd really have to look at state zoning enabling acts and local jurisdictional rules to determine this question of abandonment and intent. It's important to note that in general, nonconformities can't be expanded or changed from one nonconforming use to another. And that's a general rule that applies across all jurisdictions. I do want to mention here the concept of amortization. It's a process that allows local governments to phase out nonconforming uses over time. Some states allow local governments to establish an amortization period and to phase out nonconforming uses, and this is irrespective of intent to abandon or a finding of a nuisance. Generally, the establishment of the amortization period and the length of the period must be reasonable. So again, you see the reasonableness standard applying in zoning decisions. So I will leave it there. I'd love to hear from you on Twitter or through my website, where you can sign up to my mailing list. See you next time.